This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
Picture this. You walk out to your mailbox on a beautiful Florida afternoon,
Yep.
and there is a certified letter waiting for you.
Oh, the dreaded certified letter.
Right, from your HOA. So you open it up, you see a fine notice, and I think for most people, your stomach just immediately drops.
Oh, absolutely. Panic sets in.
Exactly. Because the absolute biggest fear rushes in, right? Can they take my house over this?
Yeah, that is the ultimate nightmare scenario for any homeowner.
It is. So today, our mission in this deep dive is to answer exactly that. We're dissecting Florida HOA rights, specifically looking at statutes 720.305, 720.3085, and those sweeping 2024 HB 1203 reforms.
Those were massive.
Huge. And we are pulling all of this from an incredible stack of legal research and reports provided by Bach Pro Se.
Right.
And just a quick side note on that, because it's Latin for oneself, it is pronounced pro se.
Rhyming with day.
Yes, rhyming with day, never proceed.
Never proceed. Good catch.
Yeah. So the goal here is to basically empower you. We want you to walk away from this deep dive knowing exactly what a Florida Homeowners Association can and cannot do.
Absolutely.
So, okay, let's unpack this. Can they actually take your home over a fine?
Well, a very important distinction before we get into the mechanics of these laws.
Okay.
To answer that, we really have to establish the fundamental divide in Florida HOA law.
The divide.
Yeah. The answer to can they take my home depends entirely on one crucial distinction. Is the money they are demanding a fine, or is it an assessment?
Oh.
Because those are two completely different legal concepts, and they carry entirely different levels of risk.
Okay, so since those two concepts are treated so differently, let's start by looking at fines.
Okay.
Because reading through that Bach Pro Se research, I realized that Florida law is, well, it's surprisingly protective of the homeowner when it comes to standard fines.
Highly protected. Actually, let's look at the absolute most important rule regarding fines, which is the statutory lien prohibition.
Okay, lay it out for us.
So in Florida, under Statute 720.3085, a fine of less than $1,000 cannot become a lien against your property.
Wait, period.
Period. Cannot become a lien.
Okay, let me make sure I have the mechanic of this right. If they can't put a lien on the property, that means the HOA cannot foreclose on your home for a sub $1,000 fine.
Right, exactly. The ultimate threat is completely off the table.
Oh, wow. Okay.
Yeah, if they want to collect, say, a $500 fine for a minor violation.
Like the paint color is wrong or something.
Yeah, exactly. Their only option is to go to court, file a standard civil lawsuit, and try to get a regular money judgment.
Which takes a lot of time and a lot of money on their part.
What's fascinating here is how that shifts the power dynamic.
Ah.
By prohibiting liens for fines under $1,000, well, Florida law strips away the primary intimidation tactic HOAs have traditionally used.
Right.
They cannot threaten your shelter over a minor rule violation.
That makes a lot of sense. You know, it reminds me of the difference between getting a speeding ticket versus not paying your actual property taxes.
Oh, that's a perfect analogy.
Right, because a speeding ticket is a penalty for breaking a rule. That's your fine. You might owe money, but the city isn't going to foreclose on your house over a speeding ticket.
Exactly.
But property taxes, those are the mandatory funds needed to keep the infrastructure running. That's your assessment.
Right.
And if you don't pay those, your house is absolutely at risk.
That is spot on. The state basically recognizes that a neighborhood rule infraction, it just doesn't justify making a family homeless.
But naturally, that makes me wonder about loopholes.
Oh, there are always people looking for loopholes.
Right. Like, what stops an HOA board from having a meeting on a Tuesday night and simply declaring, all right, to get around this, every single violation in this neighborhood is now $1,500?
Well, the Florida statutes actively prevent that.
Oh, really?
Yes. The law sets strict default caps on fines. So it is a maximum of $100 per violation.
Just 100.
Just 100. Now, if it's an ongoing continuing violation, like you built a fence without approval and you leave it up day after day,
Okay, yeah.
they can fine you $100 a day,
Yeah.
but it is strictly capped at a maximum of $1,000 in the aggregate.
Ah. Bumping right up to that $1,000 lien threshold.
Exactly.
But carefully not crossing it.
Right.
Now, the research did mention one nuance here. An HOA can technically have fines higher than that statutory cap, right?
They can, yes.
But it requires much more than a simple board vote. Like, the only way an HOA can charge more than $100 per violation is if those higher amounts are explicitly authorized in the community's recorded declaration or bylaws.
Precisely. The board does not have the unilateral authority to just invent new, exorbitant fine amounts.
Because changing the declaration or bylaws usually requires a supermajority vote of the entire community, right?
Right. Which is incredibly difficult to achieve. Getting that many people to agree to raise their own potential fines. Good luck.
Yeah, that's not happening. So, okay, if they can't easily put a lien on your house for these capped fines, how do they actually legally enforce them?
Right.
Because the Bach Pro C reports detailed a process that almost looks like a mini justice system.
It does.
They can't just slide a bill under your door. They have to follow a very strict protocol.
They absolutely do. So first, the HOA must give the homeowner at least 14 days written notice.
Okay, 14 days.
And that notice has to be specific. It must detail exactly what was done wrong, how the homeowner can fix it, and the exact date and time of their hearing.
And this hearing, it isn't just the homeowner begging the board for forgiveness, right?
No, not at all.
Because the statute requires that the hearing be held within 90 days of the notice. And it must be in front of an independent committee of at least 3 association members.
Yes, the independent committee. This is crucial.
And the definition of independent here is ironclad.
Completely ironclad.
It cannot include board members, it cannot include employees, and it cannot include any of their close family members. So no spouses, no parents, children, or siblings.
It is designed specifically to prevent a kangaroo court.
Yeah.
You know, you can't have the board president acting as the prosecutor and their spouse acting as the judge.
Right. I love the jury of your peers concept here.
It really is.
And this committee isn't just advisory, are they? Like, the board can't just listen to their recommendation and then ignore it.
Exactly. The statute gives this independent committee absolute veto power.
Wow. Veto power.
Absolute veto power. Their only job is to vote to confirm or reject the fine proposed by the board. And if a majority of that independent committee votes against the fine, it is dead.
The board can't overrule them.
The board cannot overrule them. It's a built-in system of checks and balances.
There is another layer to this defense that I found incredibly strategic in the material. It's the power of the cure.
Ah, yes. The cure defense.
Yeah, under statute 720.305. If a homeowner cures, meaning they fix the violation before the hearing, or if they fix it exactly in the manner specified in that written notice, it acts as a complete defense.
Yes, and we really need to emphasize the word complete here.
Okay.
If you cure the violation, the fine is entirely eliminated. The HOA cannot impose it at all.
So they don't just reduce it.
No, cure is not a mitigating factor where they say, oh, well, we'll cut the fine in half. It is a full stop.
Yeah.
If the notice says, remove the unapproved patio furniture,
Right.
and you remove it before the hearing, the legal justification for the fine vanishes.
Wow. That completely shifts the motivation of the HOA, and it forces the process to be about actually maintaining the neighborhood standards rather than using minor infractions as a revenue stream.
Which is exactly the legislative intent behind the statute. The goal is compliance, not punishment.
Okay, so we've established that fines are highly restricted.
Yes.
But the Bach Pro C reports show a completely different, much more dangerous landscape when we look at the other side of the equation. Assessments. Because these are the mandatory dues that keep the community's lights on, right?
Right.
So this is where the HOA does have the power of the lien and ultimately foreclosure.
That is correct. Because assessments fund essential services, like insurance, landscaping, community maintenance. Florida law gives HOAs sharp legal teeth to collect them.
Sharp teeth.
Very sharp. But even with those teeth, they cannot just foreclose on a whim. There are mandatory speed bumps built in under statute 720.3085.
Okay, let's walk through that timeline because it's important.
Yeah.
The HOA has to clear a dual 45-day notice hurdle.
Yes, dual 45 days.
So before they can even record a lien against your property in the public records, they have to send a written notice giving you 45 days to pay the late assessments.
Right. And if the homeowner does not pay within that first 45-day window, then the HOA can record the claim of lien.
Okay.
But they still cannot file a foreclosure lawsuit. Once that lien is recorded, they must send a second 45-day notice.
Oh, second one.
A formal notice of intent to foreclose. So mathematically, the homeowner has a 90-day runway to resolve the issue before a lawsuit is actually filed.
So what does this all mean for the homeowner who's just trying to catch up? Because I was reading about the payment application order in the statutes, and honestly, this looks like a devastating trap for anyone who doesn't understand the mechanics.
It is a trap. and it catches people constantly.
Explain how it works.
So when an assessment is late, the HOA starts tacking on interest,
Right.
and then administrative late fees,
Right.
and eventually collection costs and attorney fees.
Okay.
Now, let's say your monthly assessment is $150, but with late fees and interest, your total balance is now $250.
Okay.
A homeowner might logically think, well, I'll just send them a check for my normal $150 to catch up on my core dues, and I'll dispute the late fees later.
Which sounds perfectly reasonable.
It does. But Florida law explicitly forbids the HOA from applying the payment that way. Yes. The statute mandates a strict order of operations. Any payment made must be applied to interest first, then to late fees,
Yeah.
then to attorney and collection costs. And only after all of that is paid off does any remaining money go toward the delinquent assessment principal.
Wait, so let's look at the result of that waterfall. If you owe $250 total and you send a check for $150, the HOA takes that money and pays off the interest and the late fees first.
First, exactly.
And whatever tiny fraction is left over goes to the core assessment, which means your core assessment is still not paid in full.
Exactly. You are technically still delinquent.
And because you're still delinquent on the principal, the very next month you get hit with brand new late fees and brand new interest.
It creates this cascading cycle of debt.
Wow.
Homeowners struggle to escape it, and it just accelerates their path toward a lien.
It's a mathematical treadmill.
It absolutely is.
But the homeowner isn't totally defenseless once a lien is filed, right? The research details a few specific counter moves.
Yes, there are tools.
One of them is filing a notice of contest of lien. And looking at the game theory here, this seems like pulling the pin on a grenade.
Oh, it really is.
Because if a homeowner files this document in the public records, it forces the HOA into a 90-day sue or lose it deadline.
It does. Normally, an HOA has a pretty long time to act on a recorded lien. But by filing a notice of contest, you drastically accelerate the timeline.
Okay.
You are legally challenging the HOA to put up or shut up. If they do not file a foreclosure lawsuit within 90 days of that notice, the lien completely vanishes by operation of law.
But there's a massive inherent risk there.
Huge risk.
Because if you force them to sue you in 90 days, you better actually have the money ready or a rock-solid legal defense prepared. Otherwise, you literally just fast-tracked your own foreclosure lawsuit.
It is absolutely a high-stakes maneuver. I wouldn't do it lightly. Now, if you don't have a defense and you just need time to get the funds together, there's a much safer mechanism.
Which is?
It's called a qualifying offer.
Okay, let's detail how that works.
Yeah.
Because it seems like a vital tool for just buying some time.
It is. A qualifying offer allows a homeowner to essentially hit pause on the foreclosure process for up to 60 days.
60 days, okay.
To use it, the homeowner must formally submit a drafted offer agreeing to pay the specified delinquent amounts within a set time frame.
Right.
The strategic value here is that it stops the bleeding. Because during a normal foreclosure timeline, the HOA's attorney fees are constantly mounting.
And those get passed to the homeowner.
Exactly. They get passed directly to the homeowner. But a qualifying offer legally halts the accrual of those specific attorney fees while giving the homeowner 60 days to secure the funds or, secure financing.
Oh, that's huge.
But if you breach that agreement and you don't pay within the 60 days, the foreclosure resumes immediately.
Right. So knowing how to navigate those financial mechanisms is crucial. But ideally, you prevent disputes from escalating to that lien stage in the first place.
That's the goal.
And that requires utilizing statutory rights early on. For example, the right to inspect official records.
Yes.
Under Statute 720.303, homeowners have the right to access the HOA's records. And the HOA only has 10 business days after receiving a written request to make them available.
And the penalties for ignoring that request are severe.
What happens?
If the HOA fails to provide the records within 10 business days, it creates a rebuttable presumption that they purposefully failed to comply.
Okay, just to clarify the legal jargon there for everyone, a rebuttable presumption basically means that if this goes to court, the judge automatically assumes the HOA intentionally hid the records.
Right.
And the burden of proof shifts entirely onto the HOA to prove they didn't.
That is exactly what it means. It puts the HOA on the defensive immediately. Furthermore, the homeowner is entitled to statutory damages of $50 per day for up to 10 days.
Oh, wow.
So that's a $500 penalty against the HOA simply for administrative stonewalling.
Okay, I was also reading about a defense that applies when an HOA plays favorites.
Oh, this happens a lot.
Right. Say they fine you for having weeds in your flower bed, but you walk down the street and the board president's lawn looks like a neglected jungle.
Right.
The Bach Pro C reports refer to this as the defense of selective enforcement.
Yes. Selective enforcement is what the courts call an equitable defense. It's really rooted in the concept of basic fairness.
Okay.
Florida courts do not look kindly on arbitrary power. So if you can prove, usually with, date stamp photos and written logs, that the HOA is fining you for a specific violation, but ignoring other neighbors doing the exact same thing, the court can rule the enforcement completely invalid.
So they can't just pick and choose.
Right. An HOA cannot selectively apply the rules to punish their critics and protect their friends.
And if you're gearing up for a battle over something like a selective enforcement or a dispute over property use, you don't necessarily have to jump straight into an expensive lawsuit either.
No, you don't.
Because Statute 720.311 outlines pre-suit mediation.
Mediation is a critical step. Before either side can rush to a judge over certain disputes like changes to the governing documents or property use issues, the law requires them to attempt pre-suit mediation.
Okay, so it forces both the homeowner and the HOA board into a room with a neutral, certified third-party mediator.
Yes. It acts as a mandatory cooling-off period.
That makes sense.
The goal is to reach a settlement before either side burns tens of thousands of dollars on litigation. And if an HOA refuses to participate in mediation, they can be heavily penalized by the courts later on.
Right. So we've been looking at how homeowners have had to use these defenses to fight tooth and nail against overreach. But in 2024, the state legislature clearly recognized this massive power imbalance.
Yeah, absolutely did.
They realized the old statutes just weren't enough to curb the micromanagement, which triggered the massive HB 1203 reforms.
HB 1203 is a paradigm shift. It really is. It is arguably the most aggressive pro-homeowner legislation Florida has seen in decades. It directly targets the hyper-controlling behaviors that HOAs are notorious for.
Here's where it gets really interesting. Let's run through the practical mechanics of these new laws, starting with something as mundane as garbage cans.
Garbage cans.
Traditionally, an HOA could hit you with a fine if your trash bin was visible for even an hour after the truck rolled by. But under HB 1203, an HOA cannot fine a homeowner for leaving their trash can at the curb if it is within 24 hours of the scheduled collection time.
It's a practical protection. It recognizes that people have 12-hour work shifts or emergencies, and they shouldn't be penalized for not sprinting home to hide a plastic pin.
The legislation also protects backyards. It explicitly states that an HOA cannot prohibit a homeowner from installing a vegetable garden or a clothesline,
Right.
provided those items are not visible from the frontage of the property, an adjacent parcel, or an adjacent common area.
The underlying principle there is reclaiming private space. You have the right to grow your own food and dry your own clothes on your property without a committee dictating your lifestyle, so long as it isn't disrupting the public visual aesthetic of the street.
And then there's the protection for pickup trucks. I know people who have actually had to sell their vehicles because of strict HOA covenants.
Well, it happens all the time.
Well, under the new reforms, an HOA cannot prohibit a property owner or their tenant, guest, or invitee from parking a personal pickup truck in their own driveway or any other designated parking area.
Right.
The HOA loses the power to declare a standard pickup truck unseemly.
Yes, that was a huge point of contention.
But the detail in the HB 1203 breakdown that fundamentally changes the entire landscape is what happens to board members who hide documents. We talked about that $50 a day civil penalty earlier.
Yes.
But the new law escalates this to criminal penalties.
It does. And this is completely unprecedented in Florida HOA law.
Wow.
Under the new reforms, board members and property managers who knowingly and purposefully refuse to produce association records to a homeowner, specifically with the intent to avoid or escape detection, arrest, trial, or punishment for a crime, now face actual criminal charges.
Criminal charges.
Actual criminal charges. They can be charged with a misdemeanor. And in certain cases involving evidence tampering, it escalates to a felony.
Taking it from civil fines paid by the association's insurance to personal criminal misdemeanors, that fundamentally changes the risk calculus for anyone volunteering for an HOA board.
Oh, completely.
You can't just brush off hiding records as an administrative oversight anymore.
If we connect this to the bigger picture, it sends a loud message to boards. It reminds them that holding a board seat is a position of legal duty, not neighborhood royalty.
Right.
Transparency is no longer a courtesy. It is fiercely guarded by state law, and the state is willing to enforce it with criminal records.
So to wrap all of this up, The mechanics of Florida law provide massive protections to homeowners, but only if they understand the machinery.
Exactly.
If you know that standard fines under $1,000 can't result in foreclosure. If you know exactly how to execute a cure defense. If you understand the payment application traps and how to use a qualifying offer to buy time, you stop being a passive target and you start being an active, protected participant in how your neighborhood is run.
That is so true.
And for anyone listening who wants to dive deeper into the actual statutes and do their own reading, the reports at pros.tribac.com are an excellent resource.
Absolutely. Because in this arena, understanding the law isn't just an intellectual exercise.
Yeah.
In the context of an HOA, knowing these specific legal mechanics is literal property protection.
Exactly. Which leaves me with a final lingering question for everyone to think about.
Yeah.
We're seeing these new 2024 laws instituting strict limits on fines, legally protecting pickup trucks and vegetable gardens, and introducing actual criminal penalties for board members who try to hide records. Are we witnessing the legal extinction of the traditional hyper-controlling HOA? As the state increasingly steps in to forcefully champion individual property rights over neighborhood conformity, will the whole neighborhood dictator model of HOA simply age out of existence? Think about it. See you next time.
This episode was produced by Bach Pro Se. Run your own legal research at prosa.triboc.com.